Hello everyone. So it's day 33 and today I have April 5th, 2024 Indian Express newspaper and again Indian Express explained page. So here are few important articles over this page which I would like to read. First is about the levying excise duty on industrial alcohol. So whose right it is? Either a union can levy or a state can levy. This is being argued in the Supreme Court. And there is another important article over the Kachathew Island which was in yesterday's explained page also, but today we would like to read that article because there are certain international laws which are being talked about in this article. So let us see the first article, which is about the levying of the excise duty on industrial alcohol. So whose right is it is? So let us see. So excise duty levied on alcohol is a key component of a state's revenue, with the states often adding an additional excise duty on alcohol consumption to drive its income up. For example, in 2023, Karnataka hiked the additional excise duty on Indian made liquor by 20%. However, when it comes to industrial alcohol, do states have the power to regulate and tax it? This is the question that a nine-judge bench of the Supreme Court is hearing. So, what is the current case before Supreme Court? The bench, headed by Chief Justice of India D.Y. Chandrachud, began hearing arguments on April 2 on whether state government have the power to regulate and control the sale, distribution, pricing, and other factors relating to industrial alcohol. Industrial alcohol is used as a raw material to create other products and is not meant for human consumption. Entry 8 in the state list under the 7th schedule. Okay, entry 8 in the state list under the 7th schedule gives state the power to legislate on the production, manufacturing, processing, transport, purchase, and sale of intoxicating liquors. At the same time, entry 52 of the union list and entry 33 of the concurrent list mention industries whose control is declared by parliament by law to be expedient in public interest. Notably, subjects in the concurrent list can be legislated upon by both states and center, but where central law exists, the state law cannot be repugnant to it. Industrial alcohol is listed in the Industries Development and Regulation Act 1951. Essentially, the question before the apex court is whether states can regulate industrial alcohol or whether the center exercise exclusive control on the subject. So, has the Supreme Court considered the issue earlier? In 1989, a seven-judge constitution bench in Synthetics and Chemicals Limited versus State of Uttar Pradesh held that states' power as per entry 8 of the state list were limited to regulating intoxicating liquors, which are different from industrial alcohol. The Supreme Court acknowledged that a state's power to regulate consumable alcohol must include the power to prevent and or check industrial alcohol being used as intoxicating or drinkable alcohol. But the court found that the taxes and levies in question were designed primarily to increase the revenue collected by the state, not as measures to regulate the use of industrial alcohol or prevent its conversion to drinkable alcohol. Essentially, the Supreme Court said that only the center can impose levies or taxes on industrial alcohol which is not meant for human consumption. However, in a point that would be brought up decades later, the Supreme Court did not consider its prior constitution bench decision, Chaudhry Tika Ramji versus State of UP 1956, where five judges upheld a legislation enacted in UP to regulate the supply and purchase of sugarcane. This act was changed on the grounds that under Section 18G of the IDRA, that is the Industrial Development and Regulation Act, the center had exclusive jurisdiction over regulation of the sugar industry. In contrast to its Synthetic and Chemicals Limited decision, the court held that Section 818G is not meant to cover the entire field and the state still had power to legislate on matters relating to sugar industry under the entry 33 of the concurrent list. How did this led to the case now before the Supreme Court? In 1999, the UP government issued a notification introducing a 15% fee for any sale made to license holders under the UP Excise Act 1910 for alcohol used directly or as solvent for vehicles and appear in the final product to some extent. This was challenged by a motor oil and diesel distributor who claimed that the center exercised center exercised exclusive jurisdiction over industrial alcohol as per the section 18G of the IDRA. In February 2004, the Allahabad High Court struck down the 99 notification, holding that the state legislature did not exercise power over the general regulation of denatured spirits, only over drinkable alcohol. It directed the state to refund any fee collected with a 10% per annum interest from the date the fee was deposited. The decision was appealed at the Supreme Court, which then stayed the Allahabad High Court judgment in August that same year. In 2007, the court rejected the case to a larger bench, noting that the Tika Ramji case had not been brought to the notice of the seven judges bench which decided the synthetics and chemicals case. In order to determine whether states can exercise their power under entry 33 of the concurrent list or if section 18G gives the center exclusive jurisdiction in matters relating to industrial spirits, in 2010 the case was referred to a 9 judge bench. What have the states argued so far? Senior advocate Dinesh Dwivedi, appearing for the state of UP, said that the phrase intoxicating liquors in entry 8 of the state list includes all liquids containing alcohol. He said that liquor, spirit, and intoxicant were used in the excise laws before the consumption came into force. He also argued that the union's power under entry 52 of the union list does not include control over finished products, such as industrial alcohol after the denaturation process, and that is especially covered in the entry 33 of the concurrent list. In order to exercise exclusive control over regulation of industrial alcohol, the center would first have to issue an order to that effect under section 18G of the IDRA. Without such an order, that control would vest with the states, he said. Dwivedi also cautioned against adopting an approach that would reduce states' powers, relying on Justice Ruma Pal's concurring opinion in ITC Limited versus Agricultural Produce Market Committee 2002. The Supreme Court had held that states are not mere appendages of the center. The center cannot tamper with their powers. More particularly, the court should not adopt an approach and interpretation which has the effect or trends or tends to have the effect of whittling down the powers reserved to the states. The next hearing will be on April 9. So this is a news in transition. So let's see what happened in the case and what Supreme Court decided, whether it upheld the previous decision, previous 7 judge bench decision, or make certain amendments or changes. So let us see another important article which is regarding the rules of global engagement. So this is about the Kachativu Island controversy that is been going on recently in India, and it has also expanded its horizon up to the Sri Lanka. So the Kachativu controversy is being viewed as a political brownie point scoring exercise by the BJP against DMK and Congress in Tamil Nadu, but it has sparked disquiet in the strategic community both in New Delhi and Colombo. Here is why. After Prime Minister Narendra Modi amplified an RTI reply on Kachativu obtained by Tamil Nadu BJP leader K. Annamali by accusing Indira Gandhi's government of callously giving away the island to Sri Lanka, External Affairs Minister S. Jaishankar reiterated the talking point in the issue but did not go further. Asked whether the Indian government intended to reopen the 1974 bilateral pact on Kachativu, the diplomat turned politician said the issue was sub judice, referring to a petition filed in the Supreme Court by former Tamil Nadu Chief Minister J. Jayalalitha. While the controversy is being viewed as a political brownie point, also basis of the international pact. So let us see what are the basis of this international pact. When two governments negotiate an agreement, they work with the information and understanding of the issue available on the time at the time. In making the best possible decision, governments also take into account possible future scenarios and projections. States are rational actors and they carry out clear-eyed cost benefit analysis before deciding whether any deal is worth doing. Veteran diplomats and negotiators say that there is always a compromise, a bit of give and take in the negotiations. An agreement on what and what not to concede is critical. Current negotiations on the India UK free trade agreement are moving slowly because the two sides have not been able to agree yet on the specific give and take that will make the deal worth doing for both. So what makes a good deal? State parties are expected to abide by the agreements they sign. The fundamental principle of any good deal is that it stands the test of time. If it doesn't, there is a case for looking at it afresh. If it does, there is no reason to revoke or pull out of the deal. So many of the international agreements that India has signed with its neighbor have helped to maintain peace and mutual cooperation in the region, irrespective of the government or party in the power. A recent and pertinent example is that of the boundary agreements between India and the Bangladesh. The 2015 land boundary agreement was ready when the Congress-led UPA was in power. The BJP, which was in opposition at the time, had opposed it, but after Narendra Modi became Prime Minister in 2014, the party changed its position. The pact involved an exchange of enclaves located in each other's territories, which had made life for the local population difficult for more than 40 years. When the two governments decided to regularize the enclaves on an as is where is basis, India lost some territories in the net analysis. The opposition Congress, which had negotiated the deal and understood its benefit, did not make an issue of the loss of territory and did not criticize the pact. India also settled its maritime boundary with Bangladesh in July 2014, soon after the NDA government came to power. New Delhi, which lost at the Permanent Court of Arbitration at The Hague, accepted the verdict and moved on. These decisions were taken in the view of the broader national interest and strategic ties with Bangladesh, which has paid dividends as the government of Prime Minister Sheikh Hasina has cracked down on anti-India terrorism in her country and remained a steadfast friend of India. So, cost of unilateral action. Any unilateral reopening of agreements or reviewing of pacts puts a question mark on India's international credibility, especially if the agreements in question have stood the test of time. Austin Fernando, a former Sri Lankan High Commissioner to India, told the Indian Express that the BJP's attempt to reignite the Kachathivu issue might be a vote puller ahead of elections, but it would be difficult for the Indian government to step back afterward, which was a problem. It seems that this is the only rhetoric for the election, but once they had said something like this, it is difficult for the government to get out of it after elections because BJP will win. It is a problem. They and we both should think about it, Fernando said. Apart from setting a precedent that might encourage future governments to look at reviewing our old pacts with neighbors and partners based only on narrow political convenience, there is also the question of India's bilateral ties with countries and of New Delhi's international image. Thus, while India's call for a review and a modification of the 1960 Indus Water Treaty with Pakistan has been accepted in view of the history of war and disputes with that country. In case the case of Sri Lanka, a small friendly neighbor, is different. Given India's size, population, and economic and military might, unilateral provocation might spook smaller countries and led them to view New Delhi as an overbearing regional bully, an image that is unlikely to bring India many diplomatic gains. The new pro China government of the Maldives has been portraying India precisely in this manner, and there are already smaller India out movements in Bangladesh and Mauritius as well. So there are also consequences for India's credibility with its global partners and adherence to the rules-based order. This is not the ideal image for an aspiring global power which wants a seat at global high tables, including the United Nations and other international organizations. It has taken a lot of hard work over decades to build India's reputation as a responsible power. Despite not signing the non-proliferation treaty, New Delhi's exemplary track record at nuclear non-proliferation earned its exemption at the Nuclear Supplier Group in 2008. The Indo-US nuclear deal and other similar deals followed. The end of the technology denial regime was the fruit of India's responsible behavior. On the other hand, President Donald Trump damaged America's reputation by walking out of the Paris Accord of the climate change and the JCPO nuclear deal between Iran and the P5+1 countries, on which his predecessors had worked with international partners. And China's track record on breaking pacts, including with India on the line of actual control, has raised serious questions about its commitment to the global rules based order. Sri Lanka has so far been extremely mature in its response to statements in India about Kacha Thivu. Foreign Minister Ali Sabri has had the issue has said that the issue was settled 50 years ago and there was no need to revisit it. There is no controversy. They are having an internal political debate about who is responsible. Other than that, no one is talking about claiming Kacha Thibu, Sabri said. Provocative claims by BJP could cost India some of the goodwill it has earned after assisting the people of Sri Lanka with $4 billion during the country's economic crisis and helping Colombo secure a bailout package from the IMF. India should also be wary of Beijing seeking to take advantage of any potential rough edges that develop in bilateral relation. So this was about the Kachathivu Island, and uh, recently in a strike by Israel, Iran, some general of Iran was killed in Syria. So that was news in transition. So Iran has said that they will take revenge. So let us see when the revenge will be taken, and it will be covered in the subsequent newspapers. So that's all from today's newspaper, and I didn't found anything more important on today's newspaper. So we'll meet for tomorrow. Till then,